any questions you come up with, you can put in the chat as we move along, and we are going to have time towards the end for those. We'll run about 45 minutes and save last 10 minutes or so for questions. All right, we're right at 5 after. I'd like to get us started. So hello, welcome to this month's free webinar by the Green Burial Council. Today's webinar will explore funeral planning in advance, and you'll walk away with how to document your wishes for natural burial. The benefit for you today is for anyone of any age, you should be getting your wishes in writing to prevent confusion, conflict, and any unnecessary expense. So you'll learn how to appoint a designated agent, outline your green burial wishes, and best practices for communicating your plan. Today we have with us Tanya Marsh. Tanya is the Senior Associate Dean for Academic Affairs and Professor of Law at Wake Forest University School of Law in Winston-Salem, North Carolina. A graduate of Indiana University and Harvard Law School, Tanya practiced commercial real estate and corporate law in her hometown of Indianapolis for 10 years before joining the faculty at Wake Forest. She teaches property, trust and estates, and the only course in funeral and cemetery law in a U.S. law school. And she's the author of The Law of Human Remains and co-author of Cemetery Law, the Common Law of Burying Grounds in the United States. So please join me in welcoming Tanya Marsh. Thank you so much for being here today.
Thank you, Sam. And thank you, Mara and Krista, for arranging this. I really appreciate it. Let me share my presentation real quick. All right. Does everybody see that?
Yes, we can see that.
Okay. Okay, cool. Perfect. Thank you. All right. So, again, thank you guys so much for having me today to talk about this topic of funeral pre-planning. I talk about this subject a lot to attorneys, especially estate planning attorneys, encouraging them to talk to their clients about funeral planning in the context of their estate planning. And so, in my mind, planning for the funeral and the disposition is just part of the decisions that need to be made in a comprehensive end of life and estate planning process. And I know a lot of folks think about these issues without the assistance of an attorney. So I'm really happy to be able to walk through these considerations for you today. Because I see funeral and disposition planning as part of end of life and estate planning, I do want to briefly talk about the decisions, the documents, and the processes that are involved in the broader end of life and estate planning process, which I think will help make this information about funeral planning a lot clearer. So, all right. So there are four basic considerations when we're talking about end of life and estate planning, and I'm going to talk about each of them in turn. I'm going to cover what happens if you don't make a plan, in other words, what the default is under the law, and then what the options are if you do make a plan. And this all sounds terribly off topic, I know, but I promise it'll sort of all come together in the end. It'll make sense in the context of funeral and disposition planning. So we care about healthcare decisions during a period of incapacity. That's before death. A person is perhaps unconscious or they're unable to communicate. Property management during a period of incapacity, who gets to make decisions and control your property, who's authorized to withdraw money from an account to spend it for a particular purpose, things like that. And then property distribution after death. So that's where we'll start. What happens to your property after you die? And I'm starting here for a couple of reasons that will become clear. But first of all, that's the central thing that we really care about in terms of estate planning, right? We're thinking about our estate and how our stuff is going to be distributed after we die. So important to think about that in the modern age in the United States, a lot of property transfers happen by what I would call operation of law. So if you own property jointly as joint tenants with rights of survivorship or as tenancy by the entireties, perhaps with a spouse, then as soon as one of the people in that joint tenancy dies, poof, by operation of law, magically, it becomes the property of the other person. You don't have to go to court. You don't have to go through estates. That just happens automatically. The same is true if there's a designated beneficiary on some kind of a contract, like an insurance policy, a pension, a brokerage, or a bank account. If you have indicated to the company that runs that account who should get the property at the time of your death, it's poof automatically going to go to them. Again, don't have to go to probate court and all of that. If you have other property, like everybody's personal property, right? Like your computer and your books and your long play record albums or whatever, the rest of your property that you can't handle in those sort of magical operation of law transfer methods, then we have to see what's going to happen if you don't do any pre-planning or what happens if you do plan. If you do no pre-planning, then your property is going to be distributed to your next of kin via the laws of intestate succession. And that means it's going to have to go to probate court. The court's going to have to distribute out your property, but they're going to be guided in terms of who they give it to based on that set of laws. If you do planning, you can set up your will and or your trust and give your property to whoever you want. There are a few limitations on that. You can't completely disown your spouse, no matter what they do, but in general, you can kind of give your property to whoever you want. Okay, but let's look at these laws of intestate succession. So every state has their own law, but they do tend to follow the same basic structure. And that is the surviving spouse gets either everything or they get a share. In some states, they get a share depending on whether you have children and whether those children are also children with the surviving spouse. In some states, the surviving spouse just gets everything regardless of the status of the children. So if you don't have a surviving spouse, your property would get distributed to your children. If you don't have spouse or children, it gets distributed to your parents. If you don't have spouse, children, or parents, it goes to your siblings, then aunts and uncles, first cousins, and so on. It's like these concentric circles of kin. And this matters to us, as I'll talk about later on, because when we get to funeral planning, in terms of who has the authority to make decisions about funeral and disposition in the absence of a plan or documentation, most states just refer to the laws of intestate succession. So we're going to see a version of this sort of priority list again in a couple of minutes. Okay, now what about decisions about healthcare and property during a period of incapacity? If you do no pre-planning with respect to healthcare, typically spouse, and then if there is no spouse, children or parents would get to talk to the hospital, talk to the doctors, and make healthcare decisions if you're incapacitated or if you're incapable of communicating, etc. With respect to your property, nobody has an automatic right to deal with your property during a period of incapacity unless you have a spouse or some other person that you jointly own property with. And then by virtue of their joint ownership of that property, they would have a right to do things. This can create a lot of problems for folks if nobody has any authority to make decisions about their property and they have a period of prolonged incapacity. You can always go to court and arrange a guardian, but that's costly and time consuming, et cetera, et cetera. So there are ways to pre-plan to more orderly control both of these things. So I want to sort of talk through what some of those documents are. So the first one is the durable power of attorney. A durable power of attorney is a document that where an individual, so if I'm creating it, I'm the principal and I appoint someone else, they're called my agent, and I give them authority to make decisions about my property. So important thing to remember, durable power of attorney is about property and making decisions about your property. Now, what the word durable in durable power of attorney means is it lasts past the point that a person becomes incapacitated, right? So I could sign a durable power of attorney, like in favor of my sister today. And if I do nothing else, if I just sort of sign the default form, my sister would instantly today have the rights to go, open and close bank accounts in my name and transfer money and sell stocks and sell my house and sell my car and, buy me a new car and do all kinds of things with the property. It's very broad powers. If instead I wanted to have a power of attorney that would only kick in if and when I become incapacitated, I can set that up in the document. We would call that like a springing durable power of attorney. But it is important that the power of attorney be durable, because once I become incapacitated, if it's not durable, it would automatically terminate. So um, important thing just to keep in mind, power of attorney, a durable power of attorney, just about property decisions. Now, I wanted to mention that in the context of funeral planning, because in 4 states, the person who holds the durable power of attorney has the authority to make funeral and disposition decisions. That's a default matter. So you could not have that written into the power of attorney, but if you fill out the statutory form, in those states, then that person would have that power along with other power over property. With respect to healthcare decisions during a period of incapacity, we have created in the past couple decades an analogous document called the healthcare power of attorney. So it works the same way as a durable power of attorney. We have an individual, the principal, who appoints an agent, grants the agent powers to make decisions. In the case of a healthcare power of attorney, they're making decisions about healthcare, right? If I am incapacitated, I'm unable to communicate, etc., whoever I gave my healthcare power of attorney to would have the authority to make those decisions. Now, again, this is important in the context of funeral planning because in 10 states, the person who holds the healthcare power of attorney has the authority to make funeral and disposition decisions. But we'll talk more about the different documents that we can use for that in a couple of minutes. Okay, so who decides what happens to your remains? Well, again, we have if you make a plan and if you don't make a plan. So if you do not make a plan, the person who holds the right of sepulcher is the person who gets to make decisions. The right of sepulcher is defined in the law as the right of a person or a group of persons to control the remains of a deceased individual and to determine the place and manner of the disposition of their remains. If someone interferes with the right of sepulcher, then there can be tort damages. So, and money damages. You can sue somebody for interfering with the right of sepulcher. If the hospital won't give the remains to the person who's legally authorized to hold them, etc. Okay. So who holds the right of sepulcher? Well, if you don't make a plan, then we're going to look at the list of the next of kin via the laws of the right of sepulcher. And those are going to mirror in the vast majority of states the laws of intestate succession. And if you do make a plan, then we can supersede that list of the default priority under the laws of the right of sepulcher, and whoever you name in your funeral planning document that is acceptable under your state's law. Okay, so the next of kin in the law of the right of sepulcher, again, we're mirroring that priority list that we just saw for the laws of intestate succession. So if there's a surviving spouse, typically they would have first dibs, or they would have the most right, and then children Now, the states do vary. Some states say children, some states say adult children, some states say majority of the adult children, some say all of the adult children. So there's some variety there. And then parents, siblings, aunts and uncles, first cousins, and again, so on. A lot of states will then go to like a next friend, like or some interested person. It's about half the states where you have sort of this stopgap at the end of this kin list that would basically be anybody who's willing to step forward and take care of the remains of the decedent can have the legal right to do so once we've exhausted the list. There are a lot of reasons why a person might not feel comfortable with that statutory priority list. I mean, there could just be a lot of reasons. So, for example, I teach, in a law school, I have a lot of, 24 to 28-year-olds who are in my classes. Most of them don't have a spouse. Most of them don't have any children, but they have parents. A lot of them have divorced parents. And when I ask them, if somebody had to make these decisions, how easily is that decision going to be made, right? The statutes that would default the decision to the parents say the parents, meaning that they have to agree on it. And if they can't agree on it, it would have to go to court and let the court sort of adjudicate the matter. Nobody wants to be in that situation, right? It is way easier to leave a document under one of these statutes that I refer to as designated agent statutes. A designated agent statute is a statute that permits an individual to leave binding instructions appointing another person as the agent to determine the disposition of their remains. And so what I mean by that is we have this background priority list for next of kin, but if there's a designated agent statute and you execute a document appropriately under your state's law, you supersede, you jump the priority for all of those other folks. Now, 47 states have statutes that allow you to do this. Two of the states that allow it only allow it in particular circumstances. South Carolina only allows a designated agent if the designated agent wants to choose cremation. And then I believe is it Arizona or New Mexico? It's either Arizona or New Mexico that only allows it for unmarried persons. So married persons cannot execute a designated agent document. And then the other kind of statute that's related and typically handled in the same kind of document are the personal preference statutes. The personal preference statutes allow an individual to leave binding instructions regarding the disposition of their own remains. In other words, to say what kind of disposition a person would want, as opposed to naming the person who will have the legal authority to carry out those wishes. 44 states have statutes that allow you to designate a personal preference. So there's a lot of overlap, obviously, between the states that allow personal preference and the states that allow you to appoint a designated agent. But they are separate kind of concepts. Okay, so the methods that the states set up to document personal preferences and designated agent. It is the same document in all the states that allow both, but they vary in terms of what's permitted. Most, but not all states allow you to do a pre-need funeral contract only if it is funded. So an unfunded funeral contract or a pre-planning with a funeral home would not be sufficient to meet the requirements under these statutes, like for personal preference statute. But if you execute a pre-need funeral contract in most states, the surviving kin can't disturb that contract. Some states will allow you to execute a declaration with two witnesses. A declaration sounds fancy, but it's literally just like a piece of paper that you type up and say, I designate this person to be my agent, or I express that these are my personal preferences. You sign it, and then you have two unrelated people over the age of 18 and of sound mind execute as witnesses. Or they will allow you to do a declaration that has been notarized. So instead of having two witnesses sign, you would have take it to a notary public and have them sign off on your signature. Some states, you have to have both the witnesses and the notary. Some states, again, I think it was 10, I mentioned earlier, healthcare power of attorney is the mechanism for naming your designated agent. But then there are also some states that will not allow you to use a healthcare power of attorney for that. And then will. There are some states that will allow you to put it in your will. I will say, as a general matter, if you are in a state that gives you a choice, I would prioritize doing a declaration. And my general advice to people is if you're going to create a declaration, do a declaration with two witnesses and have a notary on it. I think healthcare power of attorney is the only mechanism that's going to work in some states like California, which is super unfortunate, I think. First of all, power of attorney, it doesn't even make any sense that they allow you to do it in a healthcare power of attorney because power of attorney documents terminate automatically upon the death of the principal. And of course, we're not making decisions about funeral and disposition, right? We're not executing a lot of those decisions until after the death of the principal. So it makes zero sense to me that the state is saying, this is the document that you're authorizing decisions to be made after the document has terminated in terms of its effectiveness under the law. The will is also not a great place to do it. No state requires it to be in a will. They'll allow a will as an option. Again, I think it's a bad option because most of the time we're not even reading the will until after the funeral. Because will is mostly a mechanism for distributing property after death. There's very little information in a will that has to be acted upon quickly. So in practice, most people don't even put their hands on a will until after the funeral. So if you have a choice, I strongly advocate for doing a declaration rather than a power of attorney or a will. A pre-need, pre-funded funeral contract could make a lot of sense depending on what it is that a person wants and what their financial situation is. In some financial situations, it makes a lot of sense to do a pre-need funeral contract. In others, it does not. And if people are doing a lot of planning, far in advance of the anticipated time of need, it makes even less sense to do a pre-funded funeral contract because you don't have as much flexibility. Okay, so as I mentioned, there's a variety of approaches that the states take with respect to the way that we want to memorialize the appointment of the designated agent. The same holds true for articulating your personal preferences. Again, only 4 states allow a designated agent appointed through a durable power of attorney. That's the power of attorney where I appoint someone to make decisions about my property. It also makes no sense that we would do that, again, because durable powers of attorney end at the death of the principal. We've already talked about healthcare powers of attorney. 10 states allow it. 3 states expressly prohibit it. So if you put that in a healthcare power of attorney, they will give it no legal effect. 13 states allow a designated agent appointed through a will. 2 expressly prohibit it. 23 states allow a notarized declaration. 13 states allow a declaration with witnesses. 3 states require both a notary and witnesses. And 8 states will allow a writing without either a notary or witnesses. The reason we care that the states are so all over the place is that the law of the state where you happen to die and where your body is the law that matters, right? Because if you have a person trying to assert legal authority to take control of remains and they have to deal with a hospital, a coroner, a funeral home, somebody who has the body in their possession, and you're coming forward and saying, I have the legal authority because of this document, the hospital, the coroner, and the funeral home, you can bet that their lawyers are saying, make sure that document meets the laws of our state where the body currently is. We don't care so much that it met the laws of the state where perhaps a person lives, right? So if you're dealing with somebody who lives on a border, close to the border, or when you're talking about older folks, if there's adult children in one or two other states and you're visiting those other states a lot, spending a lot of time there, you might want to think about making plans that are going to satisfy the laws of all of the states where you're spending a lot of time. Okay. So with all of this context, how can we sort of think more concretely about this and make sure that our wishes for natural burial or otherwise are respected? So strategy number one is to plan ahead. So um, I think especially if we want to choose something that is more difficult for other people to figure out logistically how to make it happen, we need to do more pre-work to smooth the path for them. So ways that you can think about planning ahead, find a cooperative funeral home if you want to use a funeral home, and consider a pre-need contract to nail down what your wishes are. Again, if it's pre-funded, then it's pretty hard to disturb in most states. If you want to do natural burial, decide on a cemetery or a burial ground, consider making the financial arrangements again in advance. And then once you've got those arrangements in place, write it all down to memorialize it. This doesn't have to be anything fancy. This is just about informing your family and whoever is going to have the right of sepulcher under the law to know what it is that you have planned and what it is that you wish to be done. Now, I just want to talk to you about one case real quick because there are some downsides of strategy one. Strategy one pretty much depends on your family being on board with what it is that you want to do and the person who holds the statutory right of sepulcher for being on board with what you want to do. This woman is Mary Florence Whalen. She lived in Iowa for many, many years. She was originally from Iowa. She was married. She had 10 adult children. She and her husband lived in Billings, Montana for a number of years. And then they were at an advanced age in their 70s. I think her husband was even a little older than she was. He went back to Iowa. They were not legally separated, but she went down to New Mexico to live with near a couple of the daughters. They were estranged. I would say estranged, but not legally separated. And then she came back up to Iowa. She was in her 80s. She came back up to Iowa to visit some of her other children and found out she had cancer. And so rather than go back, she stayed in Iowa. And was sort of she had some time to plan for her funeral and disposition. She named her sister, who lived in Illinois, as the executor of her estate, not her husband, because again, they were estranged, even though they were not legally separated. And there was clearly a dispute between she and her estranged husband about her funeral and disposition. So she and her sister went to a funeral director in Iowa and she explained the problem and said what she wanted to have happen and that her husband wanted her to be buried instead of she wanted to be buried in Billings. He wanted her to be buried with him in the local cemetery in Iowa. And the funeral director in Iowa told her, it's your husband. You can't undermine as long as he outlives you. He's the one who gets to make a decision, and there's absolutely nothing you can do about it. That was an incorrect statement of law, by the way. But that's what he told her. She relied on that in good faith. And so before she died, she wrote this letter to her husband, her sister, and her 10 adult children. She said, I'm writing this letter to all of you to let you know what I wish done with my earthly remains after my soul is gone, hopefully upward. I wish to be buried in Billings, Montana, which I considered my home when on earth. I spent 51 years of my life in Billings, and with the help of my dear husband, raised 10 beautiful children there. I bought a plot many years ago in Holy Cross Cemetery in Billings in which to be buried, and have paid for the opening and closing of my grave. I also have bought a casket made by the Trappist monks in I'm going to say Piasta, Iowa, and they will ship it wherever they are asked at the time they are informed to do so. I know you all love me and want to honor my final requests, and that is why I'm writing this to you. I just want all of you to know this is very important to me, and because you all love and respect me, I know you will see that my wishes are carried out. So after Mrs. Whalen died, the sister and the 10 children went to the local funeral home and said, this is what she wants. She is prepaid for the casket. We're ready to have the casket shipped here. She is prepaid for the cemetery plot. We want her to be buried in Billings. So she did everything that I'm sort of advocating for in strategy one, except she didn't do a pre-need funeral contract with the funeral home in Iowa. And then the husband came to the funeral director and said, no, no, I have the statutory right of sepulcher and I want her to be buried in this plot in Iowa. Funeral director correctly said, I'm not going to adjudicate between all of you warring family members. We're going to send it to the court. It went up to the Iowa Supreme Court, and the Iowa Supreme Court said she did have a mechanism under Iowa statutory law to designate an agent. She could have designated her sister if she had wanted to, but she didn't fill out the documents. She didn't create the documents correctly, and this letter did not count. So at the end of the day, Mrs. Whalen was not buried in her monk casket, and she was not buried in Billings. She was buried in Iowa, despite her wishes. So we want to avoid that kind of situation, and obviously there are because notwithstanding the husband uncooperativeness, imagine the strife that this creates, right? That Mrs. Whalen has died. All 10 kids and the sister are against the husband. It has to go to the Iowa Supreme Court to be resolved. She's sitting in cold storage at the funeral home during the months that this is going through the court system. I mean, it's just, that's got to be absolute havoc wreaked on a family. But again, there were some things that she could have done if she had been advised correctly in order to document her preferences in a legally enforceable way so that the funeral director could have gone along with the sister claiming authority and trying to execute what Mrs. Whalen actually wanted. So what we need to do is to figure out how to document our preferences and designate an agent in the state where we live. But then also, as I said before, it's the law of the state where you die that really matters. So in Mrs. Whalen's case, it wouldn't have mattered if she had documented it correctly in a different state. She needed to have it documented correctly in Iowa because Iowa was where her body was going to be. So, question number one, can I use a healthcare power of attorney for funeral planning? Just to give you an idea, because I know there's a lot of folks on this call and you guys are from a number of different states. I just wanted to show you a couple of maps to sort of help you visualize. So you can see there are a couple of states that are grayed out. Massachusetts does not have any mechanism for making this happen, nor does Mississippi. Then the states that are green, yes, you can use a healthcare power of attorney for funeral planning. So again, I think I mentioned California. That is the only mechanism that you can use, for example, in California to designate an agent or leave any kind of personal preferences. North Carolina, where I'm sitting at the moment, will allow you to use a healthcare power of attorney, but it'll allow you to do a couple of other methods of documentation at the same time. So it's really important to know whether your state only allows a healthcare power of attorney or allows other kinds of documents or what those kinds of documents are. The states that are red will not allow you to use a healthcare power of attorney. So, for example, Kansas is in a bad position because they'll let you use a healthcare power of attorney, but then they're surrounded by states that won't respect that healthcare power of attorney, right? So you want to be careful, again, with the mechanism documentation and that it matches up with the law of the state where a person may die. Okay, can I use a will for funeral planning? This is mostly a kind of Northeastern phenomenon. Again, North Carolina, I guess we let you kind of do whatever you want to do in North Carolina, but for the most part, Northeast Louisiana, and then sort of a smattering of other states. But those green states, for the most part, are surrounded by red. So I would never advise anybody to use a will for funeral planning. There is no state that allows that as their only mechanism for documenting funeral planning, and I think it is the worst of all the options. So I would strongly encourage people to not use a will. And then my go-to is a notarized funeral planning declaration with two witnesses. My big project this summer, we're in final exams right now. And so once we're done with the semester, then I'll turn to, summer projects. My big project is to finish a model form that can be used in all of these green states that would satisfy all the law of all these green states. There are still some red states. Again, California will only allow you to use a healthcare power of attorney. Um, and then the grayed out states, you can't use anything because they just don't give you the right to do that in those states. Um, but I think it's you end up at about 44 states that a notarized funeral planning declaration with two witnesses would work in. So again, in the meantime, there are a lot of statutory forms that are in the state statutes, and I'll give you a link in a couple of seconds to places where you can find what those state statutes are and to learn more specifically about the laws. But the best mechanism overall that I would recommend is to draft out a declaration. And again, it doesn't have to be fancy. I designate this person as my agent to make funeral and disposition decisions. And then if you want to say what your preferences are, then that's fine. I would have two unrelated people over the age of 18 of sound mind witness it, and then I would have somebody notarize it, all three of those signatures. Okay, for more information, I have given you, I felt very fancy. I created these QR codes. So you can like point your phone at it and like get the URL, but I also wrote the URL underneath it. I have a podcast. I gave you no link for that, but you have to go look it up in a podcasting app. Just there's my podcast. If I sometimes I talk about these things, it's all about death and other related topics. But then I have a Substack. I posted up a document on Substack this week that is a list of all of the states, the mechanisms that you can use to document your funeral planning in that state, and then the statute. So since I give you the statute in that list, then you can go look it up. I would also point you to the Home Funeral Alliance website. I've been working with a bunch of students here for a couple of years, and we've been pulling a lot of different state statutes that are relevant to people's rights in each state to have a home funeral. But all of the right of sepulcher priority lists, the personal preference statutes, and the designated agent statutes, those are all up on the Home Funeral Alliance website at that state laws, under the state laws tab if you go to their homepage. And so at the conclusion of this, I'm happy to share a PDF of this whole presentation with Mara, and she can share with everybody. But Sam, I'm going to stop there and
Yeah.
see if there are questions.
Absolutely. Yeah. So please feel free to put your questions into the chat. And yeah, like Tanya said, we are going to share links and recordings. So you'll have all this information at your fingertips. Um, and I don't see a ton of questions in here yet, but I did notice that we have several people from Canada. So I didn't know, I know this
Oh
is
no,
outside.
don't ask me.
Okay, yeah, we
It's a whole nother
I
country, man. The
exactly, yeah,
Yeah.
and we could slip down that slippery slope of countries too.
Yeah, I will say that my general understanding is that Canada has similar structures. We're both common law countries. We inherited our legal structures from England, et cetera, et cetera. But I know that there are really significant differences in terms of how these things are set up in Canada. So I don't want to try to speak to that. Sorry.
Yeah, and that's sort of the difficulty even in the states, right? Every state having their own
Every
laws.
state's doing their own thing. That's right.
Yeah. We do have a question here. What are your thoughts on the five wishes document, which can act as a funeral wish declaration? Healthcare POA is to have two witnesses and, oops, sorry, my screen is, and can be notarized, question mark. It's my understanding was created with the support of the ABA to cover requirements for most all states.
Um, I don't know. I can't, I don't have an opinion because I have not seen that document. So I will say, um, we have a little bit of, so is this a I'm sorry, is this a document that is like a POA and does other things? Or is this a model healthcare power of attorney?
It's kind of a model, but it comes in a pamphlet. I've seen it a lot with church groups and end of life groups offer it to people to be able to talk through both how they want their death to occur and then has places for those kinds of notarizations and to come in place. It's sort of a workbook
Mhm.
for people who work on are planning ahead.
So I'm just gonna throw, I haven't looked at that document exactly. So I will say that, um, again, a healthcare power of attorney is not going to work in every state for funeral planning. And so anecdotally, what I have found in talking to very experienced and very good estate planning attorneys is they have very little understanding of funeral planning. And these statutes that talk about right of sepulcher and all that are in a different part of the state codes than the part of the codes that they deal with very often. And so there's a lot of confusion, even among people who should probably know better. So I don't I don't know about that specific document. I would also say though that if you're in California, for example, you have to use a California healthcare power of attorney form. It is a specific statutory form. The same is true in Texas. So I would be very careful about using like one unified form um, because I know for it's not going to work in every state. There's
Yes.
sometimes a false sense of security with some of these forms that are widely provided because they seem like they're going to work, and then when you get down to it, they're not.
Someone did provide a link, so maybe we can get that over to you too,
Yeah, great.
fivewishes.org.
Yeah.
Um, we are getting some questions about, if you die while you're traveling, which is a
Mhm.
question I get as a funeral director a lot too.
Yeah.
So what if you died in another state? What are your thoughts on that, especially while traveling?
Yeah. So if you died in another state, I mean, you can, or out of the states.
Right.
Right. So if you die in one state and you want to have your remains shipped to another state, there are there are a couple of states that under very limited circumstances could require embalming. Um,
Alabama, I know, is one of them.
Alabama is probably the most difficult because Alabama,
Hmm.
I believe, requires it in all cases when a body's going to be shipped over the state border, right?
Yeah, that's my
Um,
understanding.
yeah, and in a couple of other states, it might be triggered by what caused a person's death or if they were infected with some particular pathogen at the time that they died, et cetera. But Alabama is probably the most problematic. But by and large, you could still have, as long as you can find a cooperating funeral home, both in the state where the person died and the state where you want the body shipped to, you could have unembalmed remains shipped from state A to state B. That's not going to be a problem. If a person dies outside of the United States and you want to have the remains shipped inside the United States, again, it's going to matter what country you die in the vast majority of cases, it's not a problem to have the remains sent back to the United States. You wouldn't have to be cremated first or anything like that. Whether or not they're going to require embalming, it is much more likely that they would require embalming to get you out of another country and to bring the remains into the United States.
Yeah. Yeah, we similarly had someone on here talk about how they must be cremated. Um, my remains must be, no, embalmed in order to have the remains flown back to where I want to have my funeral. So yeah,
If
you were kind
if
of
if the
speaking to
person
that as
died
well.
outside of the United States, that is very likely going to be a requirement of the other country. But again, there's a lot of countries in the world, and I actually did a presentation on this topic to attorneys and looked up some of the most common requirements in China and Nigeria, whatever, a number of different countries. And so there are some that require it, and then there are others that do not. But that's you really have to look. You would want to look at the State Department website. And then there's going to be an informational sheet at the State Department website for what happens if an American dies abroad. It's sort of a fun rabbit hole to go down.
Yeah. In my experience too, and I'm noticing someone recommending in the chat that there are religious exceptions. So maybe contacting a Jewish funeral home or Muslim funeral home that can kind of help navigate some of that too. I had I received remains at the funeral home I worked at, and the person was Muslim and they were shipped on coal, which we found
Mm.
interesting, and they were
Yeah,
unembalmed.
yeah,
So yeah, it
yeah.
really depends. I have another question here. Can you tell me about green burial on someone's private property? Just another common one that we get at the Green Burial Council too.
Sure, sure. So, well, okay. So it's going to depend on the law of the state. It's also going to depend on the law of the locality in which the private property is located. But as a general matter, in the United States, the states don't there are some states that do, but most states do not require you to be buried in an established cemetery. So you could be buried on private property. The main restriction is the zoning law of the locality in which the property is located. And so there are some states in the United States where every square inch of the state is zoned. There are other states in the United States where only the towns and the cities are zoned, and then you get out into, more rural agricultural land, and there's no zoning, or there's extremely permissive zoning. Um, and so if you're in sort of unzoned or very permissively zoned land, you can probably bury on private property with permission of the landowner. In towns and cities, it's almost impossible.
Okay, those are the questions I'm seeing. I guess if we don't have any more questions, I do just want to remind you all that these are free webinars that we put on. We are thankful for any donations that you can make in order to keep these going. Um, Tanya did mention how you can follow her and follow her work on her podcast and even over at the Home Funeral Alliance website. So you can also get those links in the email that we send you. So let's see, just making sure we have no last questions here. Do just want to thank you so
I
much,
I
Tanya.
did have one. Could I add
Sure,
one question?
absolutely. Yeah,
Just
we've got the time here.
so the one graph or the one map, I don't recall which one it was in the three that you showed. It had a number of states that were yellow where it said maybe, and
Yes.
and I was just kind of curious, like what connotates maybe, like why that would be a thing, if you don't mind answering. Thank you so much.
No, that's a great question. Thank you for asking that. I should have mentioned that. So the yellow states were on the can I use a healthcare power of attorney? And I said maybe because the state statutes don't expressly say you can't use it. They say you have to have a declaration and then either with a notary or witnesses. So if your healthcare power of attorney, if we can successfully argue the healthcare power of attorney is a declaration with the notary or the witnesses, then it could maybe satisfy the requirements of that state. I would be nervous about trying to argue the maybe, but that could be, if that's all you got and you're now dealing with the funeral home, it's at least worth a shot to argue that that would meet the requirements. But I wouldn't do that as my first attempt.
Awesome. Thank you so much, Tanya. We really appreciate your expertise and time. And thank you, everybody, for joining us today and supporting the Green Burial cause. We really appreciate it. We hope to see you at our next webinar next month.
Thanks so much for having me.
Yes, of course.